Changes in the law for 2019. By a show of hands, how many of you manage communities that have just been developed or are in declarant control? One?
Well, there's a few that I've received.
Okay. Do you ever deal with construction defect?
I have not.
You have not, but you might. So before we get into the construction defect changes, because I'm going to kind of skim over that since it's probably not going to be that relevant for all of us. Bottom line is what I'm going to talk about, with the exception of one of these laws, become effective August 27th. And I'm going to focus on a few slides because that's probably going to take up the majority of our time and probably going to be the source of most of your questions. Probably not for this one, though. For construction defects, they did have some Purchaser Dwelling Act revisions. And we can email this PowerPoint to you if you want to dive into the detail. And my partner, Mark Holmgren, actually did construction defect litigation for 20 plus years, 15 years. So he knows this stuff. I don't do CD work because I work for the developers. So I know enough about it to get me in trouble. But basically, this allows you now, extends, I'm going to summarize. This extends now to the ability to sue subcontractors. And it also gives the ability of subcontractors to cure the defect through the inspection and coming out and actually doing work to cure their own defect. So it helps the association include more people in a construction defect, because we know with more people is more insurance. But it also, because it does that, it gives these subcontractors the right to go out and inspect, just like we have to do if we're going to sue the original developer, the general contractor. Make sense? So that's the nuts and bolts of construction defect issue. Now let's get into a few other ones. House Bill 2230. This amends these two statutes. And I put this in here because some of these you really don't care about. Others you will care a lot about. But House Bill 2230, we put this one in here because this deals with garnishments. And we do a lot of garnishments. So, and I wanted to explain this a little bit to you because sometimes you have questions for us like, why is the garnishment taking so long? Because we have to serve the individual, and sometimes they avoid service, so that means we have to go back to court and get an alternative service order. Or sometimes when you're dealing with garnishment, it doesn't matter, we have to personally serve them, period. So this statute allows us now to serve via certified mail, return receipt for garnishment. Now, sometimes you're thinking, well, okay, and this is what I was thinking, is like, great, why didn't you just put certified mail and regular mail? Because who's gonna, if they're not gonna respond to my process order, you really think they're gonna claim or sign on it for certified mail? They'll probably end up unclaimed. But this allows us now, hopefully, to speed things up a little bit. But just note that because it's certified mail return receipt, you can serve it. Let me scoot this over.
So Clint, what happens if the certified mailer gets returned unclaimed? What would the next step be then?
Yeah, well, if it's unclaimed, I think as long as you send it out via certified mail return receipt, I'd probably being safe. The statute doesn't really tell us, so for our firm, we're probably just going to ask for alt serve order anyways. But the good news is if they sign them for it,
Yeah.
we've got valid service, and we file that with the court.
Oh.
And it will speed things up. And the nice thing is this is both for the garnishee, meaning if you work, whoever you work for, or the bank, and the financial institution. So it should speed things up. If you're trying to serve an employer, they're less likely to avoid you unless they are a small employer and or it's like the employer is the employee you're trying to garnish. But in bigger corporations, bigger entities, we should be able to get service effectuated much faster. Okay. Short-term rentals. This is a fun one.
Yeah.
And you're going to like this. So, what happened 2 years ago when it came to the cities?
Got out because they're not allowed to enforce any rules on short-term rentals.
Right, the legislature thought it'd be a great thing to say cities, Airbnb, VRBO, short-term rentals, hands off. Can't do anything about it, period. Prohibited, banned. Well, for the last 2 years, the cities have been getting complaint after complaint after complaint from not only neighbors, but you, the managers, and us, the attorneys, and just basically these representatives and the senators have just been getting, their constituents have been giving them complaint after complaint. So they wanted to correct it a little bit. So they came up with a middle line approach. They give cities some limited authority to enforce short-term rentals, which is really cool. And here's the authority. There's a couple of bullet points here. First of all, it allows the cities and counties to regulate the short-term rentals by doing the following, okay? So they can require landlords to register their contact information. So if the city gets a complaint from a neighbor, they can then give the contact information of that home to the neighbor to contact directly. So if, Carl, you are engaged in renting at short-term and your city has the requirement that you give your name and your phone number or your property manager's name and phone number to the city, that's what they have to do. And if you don't, it's a code violation. So if you're the next door neighbor and you've got a problem with loud parties, you can call the city and they can give you the contact information. Okay? And notice this is a quote from the statute. Responsible for responding to complaints in a timely manner in person at any time of day, end quote. So what does that mean? I'm pissed about my next door neighbor. I want to meet with him on site. Does he have to meet with me in person? According to the statute, yeah. At any time of day. This is so crazy. It's great news for us, but it's also crazy because now attorneys have to go to court to interpret what day, any time of day means. Is it during normal business hours? Is it outside of normal business hours? We don't know because the statute doesn't say it. And whether in person is unconstitutional or unreasonable, enforceable. So
1 in the morning when a wild party is happening at the unit.
yeah,
Right.
I think if
Because
I
the
go,
short-term rentals are having
Yeah.
a rager and
yeah, exactly.
neighbor
That's what this is
call
for.
the owner and say, you're coming here now.
That's exactly
And
right.
the
That,
owner lives in Canada.
in fact, what you are saying is exactly why they put this in. There were discussions back and forth with lawmakers, and that's exactly the scenario they're talking about to help prohibit and protect. So, yes, I think if it's litigated because the investor owner doesn't like this and doing that, that this is ultimately going to be deemed enforceable.
But
under
how's the
those
city
terms.
gonna regulate that? How are they gonna know who's short-term renting and needs to give them their name and
Hold on.
contact info?
Good question. So here's some additional information. Also prohibits short-term rentals to be used for non-residential purposes that would otherwise require a license from the city. So if you are going to go rent a really nice place in North Scottsdale because you're getting married, and you're gonna have a wedding on site and do all sorts of wonderful things, there's some things that require a license from the city because it's a commercial purpose. Well, this prohibits you from renting on a short-term basis through Airbnb or others if it would otherwise require a license from the city. Okay? So if you're going to have a big event with a band and with booze, obviously those things require licenses. So you can't do that kind of stuff if it's going to be used as a short-term rental or through Airbnb. Requires all online, here's an interesting one, all online lodgings to have a current transaction privilege tax number and include it in all advertisements. So if you go on to Airbnb, now landlords have to actually have this information on their advertisements. There's got to be a place on these websites or anywhere they advertise that the place is available for rent. This, which is interesting, and I don't think many folks are going to be doing this. There's more. There's penalties, which we're going to get into. But now to answer your question about how the city's going to know who's renting, it's up to us. some cities may have some things in play. You can go through, if people are honest about it, you can go in and see who's renting, who's listed as rental property, but a lot of people are totally off in dark zone, right? So it's up to us to make the complaints to the city, and with this now, it arms them with tools to go back out and inspect, and if they see it and know it, or if I'm gonna email the city, I'm gonna email screenshots of the thing up for sale on Airbnb.
And it sounds like if they have to have a privilege tax number, the city would be collecting some kind of privilege tax, obviously. So maybe they're gonna assign somebody and they're gonna have a department created, and that's all they do is go on these short-term rentals and find these people and make them get a privilege tax number.
I think you'll see that some of the cities are going to be much more aggressive about this than others, because it's a bigger problem in some cities. But this gives our cities what they need to help enforce. And the nice thing is if you think about it, how many times did you wish over the last 2 years you could call the city and push the problem off to them? Now you can. Because even before, let's say I had this scenario where our CCNRs were silent about short-term rentals, but the condo community in Scottsdale was in an area that was zoned as single-family and prohibiting short-term rentals. And so we called the city and they took care of it. It's actually right across the street from your place. But like across the street on the other side, the other community called and said, hey, we want the city to do something about it, but they happen to be in a zone where the city couldn't do anything. This isn't based on zoning. This is based on all people that engage in Airbnb. What the cities end up doing with it is yet to be seen, but at the end of the day, effective August 27th, this is in play, all right?
What department in the city would you reach out to specifically for that?
Code enforcement. I would go to code enforcement, the same people you used to bring these complaints to, and if they need to redirect you, then they'll tell you. And by the way, can you all do me a favor, since this is back and it's new? When you have this happen, you call in, can you just report back to me? I'd love to know what they're doing with it in each of the cities, so that I can help explain it around when these questions arise. Yeah.
So I'm kind of hung up on the first part that says it allows them, it doesn't require them to regulate?
Yeah, I need to take a look at the actual statutory language, but I do think it's discretionary. I may be wrong, but I think it's discretionary, not mandatory. Yes. Just like I'm 99% sure it's discretionary, because when the law was around that allowed cities to zone, some cities cared about it, some cities didn't. It was just up to them, because they were on the body end of themselves. So I'm almost positive that this is discretionary. If it's not, I'll email you directly. If you don't hear from me, just assume it's discretionary. Sound good?
It sounds like when the city is required, that everyone's required to have the privileged tax number, when the city is contacting them or they go to apply for that tax number, then at that time the city is allowed to ask them for their contact information so that they can be contacted any time of the night or day.
Yeah, either that, or else if you, the manager, getting complaints, you can contact the city and say, hey, what's the contact information for this individual? They're like, what are you talking about? You say, well, they're an Airbnb, and they're like, well, you don't have that on our record. So they may get pissed now, and they may end up taking matters into their own hand. If there is an opportunity for tax consequences, they may explore that possibility further. Whether there is or isn't, I'm not going to get into that now, because I just flat out don't know whether the city's going to look at this issue.
Would that online lodgings include Craigslist or anything that you put online?
Yeah, any advertisement, period.
Advertising.
So if you go online because your next door neighbor's engaged in Airbnb or whatever, and you want to prove it, you go online, you type in the address, or you just look at the map and you see it. Yep, sure enough, there's the little pin right there showing it's my neighbor's doing Airbnb. If you click on it and you don't see this, then take screenshots and send it over to the city, code enforcement. If they do have policies in play, because it is discretionary, 99.9%, right? Then if they have the option to enforce now. What is a more interesting question now is, okay, now that the city, let's just assume the city is regulating and requiring these things. A lot of your CCNRs have a provision in them that say any violation of any federal, state, or local law is a violation of the CCNRs. So, my personal opinion is with this doesn't mean you can flat out prohibit them from renting, because we have the other statutes that say unless it's in your CCNRs, you can't prohibit short-term rentals, right? So there's, for condos, 33-1260.01 that says that if you want to restrict rentals, it has to be in the CCNRs, that's subsection A. And the Planned Communities Act provision says the exact same thing, and that's 1806.01A. So I don't think you can actually just prohibit them from renting under your CCNRs if they don't have this stuff with the city. But what I do think is you can send them a violation letter if your CCNRs say that it's a violation of local law.
Or minimum lease term.
You got to be careful with that too, because if the, or minimum lease term. Because you got to be careful with that, because if you violate them for, let's say, violating this local city law, if the city's not doing anything about it or deems it's not a violation, then it's not a violation, right? So, but if the city said, yeah, this is a problem, or they're doing their own thing, you as an association can continue that process too if you've got that kind of catch-all provision at the end of your CCNRs. Does that make sense? Fantastic. So let's go over some short-term rental violations. Here, this is fun. If the owner is in violation, the state may, there's that may again, right? May impose penalties as follows. $500 for the first violation. $1,000 for the second violation. And then $1,500 or 50% of gross monthly revenue, whichever is greater, for a third violation. So they wanted to make sure there's teeth there. And this money doesn't go to you, this money goes to the city, but because because there are now teeth to this, hopefully the legislature is hoping that it calms things down from the city's perspective. I don't know if it will or will not. We'll see. Time will tell. But the good news is we have this now. All right? Any other questions about short term? Yeah.
So what you're saying is effective August 27th, if an owner is in violation, the state can impose these penalties. So as the HOA management company, we could actually send an email blast to the homeowners of a community that has a problem with short-term rentals and say, new laws have been passed, if an owner's in violation of, the short-term rental laws, the state can, penalize them for these things.
Yeah.
We can just let them know that, just because a lot of people aren't familiar with the laws.
Here's what I would do. If you're wanting to do an email blast, the first thing I would do is I would contact the city to confirm they, one, know about this, which they should, but two, confirm whether they're exercising their discretion to enforce it. If they say, yeah, we are, I got to just email code compliance. They say, yeah, it's a great law. We're really excited about it. Then send your blast out to the community and say, look, this law is in play. We encourage you to register. And if you do have the city, state, federal, state violation law at the back of your CCNRs, that language, I'd say, look, if you don't get it all registered in time, you might be in violation of section 8.2. It requires you to be in compliance with local laws.
So some of these CCNRs, as you know, are written like in the Stone Ages, and they don't even know what short-term rentals are, address them in the CCNRs a lot, unless they've been amended, and a lot of them haven't. But they do have the minimum lease term of like 30 days, say. Or some communities don't even have a minimum lease term, but a lot of them are 30 days, 60 days.
Whether there has, bottom line is this, that's a different question for a different day on whether CCNRs allow some of the association to prohibit short-term rentals. We're talking about whether the association can force the homeowner to register with the city? And the answer to that is yes, if, one, the city says it's a requirement, and two, your CCNRs have the requirement that everyone comply with all local, state, and federal laws. That's all. And now the next thing is can you send a newsletter? Absolutely, so long as you verify those first two things. Okay. No problem. Here's the next one. Senate Bill 1094 impacts these two statutes in the Planned Communities Act, and it's 33-1801, which is, and 1802, which are the definition sections. Interestingly enough, a pre-1974 HOA, any of you incorporated before 1974? Yeah, and your planned community, you have a planned community? Doesn't apply to condos. So if you're condo world, no, we're not talking about condos. Planned community, older what happened is up in the Sun City West area, they lost a lawsuit, and so this is what I've heard, but I do think I don't know if they actually lost the lawsuit or they got some really adverse rulings, but they were in a world of hurt with some, in their minds, for some rulings that were coming to them. So they want, basically saying they violated the Planned Communities Act. So from what I understand, they wanted to just get rid of the Planned Communities Act so that whole thing would go away. And so they went to the legislature and they were able to, the first part of the bill just said, hey, look, flat out, if you were incorporated before 1974, you are not a planned community, period. That creates all sorts of major problems for all of our old planned communities. So CAI and AACM and a couple of other groups got together and they did a big brain trust on this, and they changed some things around to make it not so bad. So here's what the governor signed into law. If you are a pre-1974 HOA, you're not subject to the Planned Communities Act if these things are occurring. One, sorry, I should have put a parenthesis one there. Finish this last time today. One, the CCNRs do not give the association a right to enforce. And two, the CCNRs must provide that owners are required, this should have been, the CCNRs do not provide that owners are required to pay assessments and that owners are mandatory members. So you're not subject to the Planned Communities Act if these two things are there. Most of the time, 99% of the time I've seen CCNRs, I've seen a couple of communities in my history of representing communities where they could be outside of this definition. But how many times do you see a planned community that says you don't have the right to enforce? Or how many times do you see CCNRs where it says you don't have to be a mandatory member of the association, or you're not required to pay assessments because they're voluntary? There's only a handful of these communities in the state. There's a couple on the east side. There was actually litigation over this called Dreamland Villa v. Ramey. You know the Dreamland Villa case?
I have a riddle there.
So that's exactly what you're thinking of. So this is kind of similar to that. And there's some on the west side, obviously, which is why we have this. So that's if you're not subject. But here's the fun part. Let's say you're not subject to the Planned Communities Act. Well, you can opt in if you're a community. All you need is simple majority of all members to opt in. And oh, by the way, guess what? You opt in, you don't like it, you can opt back out. So, same thing. You can opt out by the same exact procedure. Simple majority of all owners. Has to be recorded, so everyone knows whether or not you're in the Planned Communities Act or not. But this new law doesn't give any kind of quote on how many times an older community can opt in, opt out, opt in, opt out. I can think of one of my associations in particular who might be, in 40 years from now, if I'm looking back at the recorded documents, in, out, in, out, in, out, every time a new board comes in and it goes out. So, kind of fun. Questions about
That Dreamland, they call it voluntary HOA.
Yeah, they do, yeah. So, any questions about this? It's kind of an interesting, fun fact. Chances are you're going across it. Okay, next one. This is a good one for you to keep in mind because this happens to all of us. I get a call from you saying, hey, look, we've got a problem with our contractor. Now the registrar of contractors can issue cease and desist orders to contractors. But what's even more interesting is, how do I collect my money for all the damages? This specifically authorizes HOAs the ability to receive monies from the recovery fund if two things happen. First, you have to be post-turnover. It can't be declarant controls. And the second thing is, the person that did the damages is a licensed residential contractor. Okay, so for you, make sure when you're hiring these contractors, if you want to have that option for recovering from the recovery fund, that you hire residential contractors, not commercial contractors.
Can
Which-
they be licensed in both?
Yeah, lots are. But
So
just
they're
make sure you have,
and
the important point is you got the residential commercial contractor, and they present themselves as such, and I think, I may be wrong, but I think they're actual residential contractor license numbers versus commercial contractor licenses.
Yeah, they're different.
Yeah. So as long as they've got that, that's how you know whether you can dip into the recovery fund, because you've got a residential contractor's number as opposed to the commercial contractor's number.
even if you hired them for commercial purposes?
Well, I don't see how any of you are going to hire anyone for commercial purposes unless you manage a commercial condo. Anyone here do commercial condos? A few of you? So this is likely not going to come into play because you're not going to use a residential number for a commercial job. This is really only for your HOAs, your homes, your communities. And notice it has to cause damage to the common elements, the common area. That's where the HOA gets to dip into the recovery fund. If they cause damage to someone's home, chances are HOA doesn't have that claim. Who does? The homeowner. Okay? So here's your maximum recovery, 30 grand. So if it's a job that you think is less than 30 and you don't want to pay 30 grand in attorney fees, look into the recovery fund option now. It's a really good one for you. This is still August 27th. Increases the lien statute of limitations from 3 years to 6 years. The nice thing with this now is, I wouldn't say necessarily you should wait 6 years for your ledger to increase. That's really bad news, especially for some of you guys that have quite a high amount due on a regular basis. Don't wait very long to foreclose or collect or whatever. But I've got several master plan communities and other communities where they have a semi-annual assessment of like $100 or something. And so when I go to court, I have to foreclose within 3 years for my client or it's beyond the statute of limitations. So the judge looks at us and goes, why are you foreclosing on $300? That's dumb. And I tell the court, well, Your Honor, sorry, but we have a 3-year statute of limitations. Like, okay. But at least kind of a sour taste in the judge's mouth, and that's sometimes reflected in the ultimate attorney's fees award. So what this is hoping to do, according to the sponsor of the bill, Representative Farnsworth, is it's hoping to allow people time to pay off their debt and not to rush off to court to resolve matters. But like I said, if you've got, you don't want to wait 6 years if you've got a high amount that are due in the way. Okay? Same bill, Senate Bill 1535. It applies to both condos and planned communities. This is an important one for you guys. This deals with statement of accounts. How many of you have heard of the statement of account changes? Raise your hand. Not too many. Perfect. So this is important. If you weren't paying attention before, now is the time to pay attention. You have to send, now this is where we get into January 1st, 2020, by the way. You have to send statements of account in lieu of a coupon or payment book. So gone are the years where you can send a coupon book or payment book at the beginning of the year and expect them to just make payments based on what they're returning back on the coupon and payment book.
That's if they don't have professional management.
Well, it's two things. If there are less than 50 units, and they don't have, even if it's less than 50 units, they still have to do it if there's professional management. But this only is excluding people that are very small and self-managed. Everyone else has to do it.
So if we're a professional management company and we have properties that are less than 50 units,
If you have a professional management company with 10 units, you have to do it.
a community that has 10 units.
Yeah, because you're professionally managed. So you have to send the statement of accounts in lieu of the coupon and payment book. It must be sent every time assessments come due. So if you're monthly, they get a monthly statement of account. If you're semi-annual, they get a semi-annual statement of account. What do I mean when I say statement of account? Anyone want to comment on that?
It's the CO, correct?
Yeah, it almost looks like a mini ledger, right? If you send the statement of account, it breaks down what they owe. Absolutely.
Even if they're in collections?
We're going to get to that.
Okay.
Sounds like it's like a bill, like an invoice statement,
Yeah,
because it has to be sent every month. If they're monthly, they
Right.
get an assessment
yeah. So
statement.
for most professionally managed, your principals know about this, and they're gearing up with the software. A couple of complaints that I've heard from some of the owners of companies and presidents is, well, we deal with X bank, and they tell me that they can't even track payments without a coupon or payment book. I don't know, that's the bank's problem, if that's the bank, but they're gonna have to figure it out before January 1st, 2020, or else all of you guys are taking your business elsewhere.
You can print a statement that has a payment part on it
Exactly,
that you
and
just
that's
have.
what most software is equipped to be able to do. So some of you are like, duh, we do this already. Some of you are like, well, actually, this sucks because we didn't do this before. So it's kind of a mixed bag, but at the end of the day, it's a requirement, and you can charge a reasonable fee. So,
That's not gonna fly in Scottsdale.
yeah, how much more money is that going to cost the association? It's a problem. I've actually had to talk to a couple people, but look, it's an important thing to do. I think that when I get in all these collection disputes, the two main arguments I always hear are, number one, why in the world are we here? This is the judge talking to me. Why in the world are we here? The owner's saying they never got any statements until your letter, which they said they didn't get. But when I have like letter after letter of the statement of account, month after month after month, that argument never gets anywhere with the court. And the judge then is annoyed not with the association, but is annoyed with the debtor. So, and I think that doing this rather than the coupon book is going to solve a lot of the problems too. Part of the reason why this law came about was the sponsor of the bill, Farnsworth, had a personal experience where he bought a unit and he didn't know the amount that was due, he didn't know he had to pay anything, he didn't get, the monthly statements or whatnot. So he wants to make it a requirement for everyone to have. And I've heard arguments for and against and hatred about the bill and pros about the bill. My personal opinion is this is probably going to hopefully solve problems, and I know it's going to make my job easier when I get the account. Because if I have to go to court, putting a stack of letters together as exhibits like this, rather than just, hey, they sent them the payment coupon book, whatever, it's going to be a much stronger persuasive argument for me. So I personally like it. I'm glad it's there. And because it causes extra work, it's not fair to the management company to have to do that for free. So it allows you as the company to charge a reasonable fee for that. And I think that's why, part of the reason why AACM sponsored it, CAI sponsored it, we all sponsored it, and ultimately we're in favor of it, because it hopefully will reduce the amount of confusion out there. Yeah.
And send means email or mail?
No, it means mail. We're going to talk about electronic in just a minute. Yeah, send means mail.
And Farnsworth, it was from my association, the title company where the address that he gave, and which I showed it to him, says this, and so that's where those statements were going. We
This is
always-
your community?
Yeah.
That is
I
interesting.
had many emails and phone conversations with him.
That is interesting. And So, yeah, look, there are difficult personalities, there are not so difficult personalities. The reason behind this is, in my mind, stupid. Come on, you know you gotta pay dues, contact the
That's the
manager,
number one excuse, I
find
didn't
out.
get my statement, that's the number one excuse.
Yeah, I know, and it's stupid when you're supposed to be sophisticated and smart and whatever. But at the end of the day, while I think the reasons given behind this are frankly dumb, I'm happy it's here because it's gonna help us avoid the dumbness moving forward.
But there is still one flaw in the whole thing is, so most title companies, when they see that the quarterly statements that say April 1st, they close on March 27th. They never, I would say, I'm seeing it more and more that title is not collecting the HOA fee. So here they're like, well, I didn't get a statement, I moved in, I closed March 27th. Well, of course you didn't, we sent it out the first week in March. And so whose fault is that? We sent it out, but it went to the former owner. They should have collected that in escrow at
Yeah.
closing time.
I think it's
Because they were so
title's,
close.
I think it's either title's fault or it's the owner's fault for not giving the new number and the new addresses. But at the end of the day,
But we would have sent it out already, so even if we had
Yeah.
the right address, we would have never
Yeah.
sent him another one.
the only time I can see a potential liability for the association is if somebody goes to closing, you're notified of closing, you send out your disclosure statement, the $400 disclosure statement, and that's screwed up. That's the only time I really see this as an issue for the HOA. The rest of the time, it's somebody else's fault. All right, so going, Vicki, to your question, you can opt in to receive these electronically, but it's entirely up to, they have to do it themselves. They have to, and you have to prove that they did it themselves. So if you say, hey folks, in an email blast, hey folks, all you guys get is a statement of account, get us your email. If you don't get us your email, we're not going to send it to you. You have to do all regular mail until everyone opts in that wants to opt into electronic. This is when it stops. It stops when you forward it to me or another collection agency. But even then, if I send out my demand letter and they come back to me and say, hey, I want a statement of account, I then have to go back to you and ask for you to send me one. We already do that anyways, right? They say, I want to validate my debt. We're saying we need a ledger, or we log into your software and get your ledger. By the way, if you guys, for the work with my firm, if you don't have access for us to access ledgers automatically, I know lots of you do allow us to access them automatically, it really speeds the process up for us. It cuts your life down tremendously. I'll even buy a tower and put it in your office and log in remotely through LogMeIn to do that. Just FYI. Okay, moving forward. So that stops for you once it's sent to us or your collection agency. Any other questions about this? It's pretty good stuff. I like it. This is the part where everyone's going to complain because of these extra fees that are generated. But you're not expected to do the work for free. And I think this is outweighed when considering how this will help everybody keep on track. Now, this is on your handouts because this is another really important one we need to talk about. This comes from this same bill, but the effective date for this part is August 27th. The only part for January 1st, 2020 is that statement of account stuff so that you guys have time, get your software in place, get your bank squared away. But this is important. Look, turn with me first to the very bottom here. This all capped in bold. Before you send an account to one of us, you have to send this statement exactly as it's written to the debtor. So, it either needs to be all caps or bold. As the statute says, it must be all caps or bold. I like bold. That's just me. My disclaimers when I send in the debtors are all caps and bold. But it has to be sent exactly like this. This is actually cut and paste from the statute. The statute has this language in here. It says, thou shalt send this to the debtor. Okay? What's interesting is, okay, so you send out your letters under your collection policy, you get to the very last letter, this should be on it. Once you send it, you have to wait 30 days. You can't send it to me within 10 days, you can't send it to me within 20 days. You have to wait 30 days for them to respond to you. Once the 30-day period is expired, you can then forward the account off to us. Okay? Does your Okay, so it also has to have the name and information of the owner who they have to contact to pay. So whoever your contact is for them to pay has to be on that notice. The next one here, the most recent address for the owner. You have to have the most recent address, and that's them giving it to you. That's kind of a no-brainer. You have to send this via certified mail, return receipt. Not just certified mail, but certified mail return receipt. And my personal opinion is I would send it via regular and certified return receipt. That's just me. You don't have to, but you have to do that. At least this is the mandatory requirement. I like the idea of regular certified return receipt because if they don't claim the certified return receipt, then we can say it was sent regular mail. Because when I'm in court, I get to argue this really cool law called the mailbox rule. The mailbox rule says that if I put something in the mail via regular mail to an address, it's deemed delivered in most cases. So if I get an unclaimed here, they might come to court and say, oh, I was on vacation in India for 20 years, so I couldn't claim it. But if it's regular mail, they can say the same thing, but at least I can still use the letter and try to argue mailbox rule. Make sense?
Is this kind of a demand statement then? Because this is like what we do for a demand letter. We give them 30 days and we do certified mailer and all this.
Yeah, so this is
something we would put on the statement if they're
no.
delinquent or ready to go to
This
collection?
is not something you put on every letter. This is your final letter at the end of the road for you.
Like
Before
demand
you're going to
letter,
send
that's what we
it,
do.
whatever your letter is called, the last letter you send before warning them it's going to go to attorney, this is where you put this on there, and you make sure that your letter has the contact information of who they need to contact. Okay? So if it's not done, then I can't collect.
So this doesn't have to go on their statement as
No.
well then? They
No.
get that 30-day letter
No.
with this verbiage on it and then the statement, their monthly statement that we're supposed to give them.
No, this is your
gonna say this.
No, this is your checklist. So before you send this to an attorney, boom, boom, all these need to be checked off. Bop, 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 bop. If you've got a collection policy, and you want to make sure this is clear in the policy, you can revise the policy to include it if you want. But if you don't want to revise the collection policy, I really don't care if you do or don't. You just have to make sure your final letter on that collection policy has this language in it. That's all. And just change it to make sure it's certified return receipt. That's basically it on that. I know here's a question that we had asked to us when we debated this back and forth at our staff meeting. We had Monday afternoon staff meetings. And we were talking with our collection paralegals and the attorneys, and we said, okay, let's say X management company sends us an account on August 29th. Does the law apply to this? So what I have to do now is I go back to you and I say, okay, I need you to send me not only the ledger, but I need all of the letters that you sent beforehand, the lot file, so that I can audit the file. Because if I don't see this, I have to see two things. I have to see this, and I have to see that you've waited 30 days. If I send out a collection letter on day 20 of you sending this, I'm liable for the FDCPA, potentially, the Fair Debt Collection Practices Act. And that's liability on me. And it's $1,000 per violation, plus the attorney fees. So this has created a heightened amount of auditing that we as the law firms have to do before we can collect. And if you, because this hasn't been around, if you send it to me and we see there wasn't one sent, we're just going to have to ask you to send one additional letter and wait another 30 days before we can step in. So don't get mad. It's unfortunately just the nature of of the law and the nature of the beast, and I'm okay with it. I like this language. I think it's gonna hopefully help people pay off their debt. You are already telling them in your letters, it's gonna be sent to an attorney, but hopefully this all caps or bold or whatever, or both is gonna help them really understand. Chances are, it will probably, if you throw out a net of 20 people, it might make one or two more people pay, but it's not probably gonna have that huge of an impact. Make sense? All right. Do we have any questions about these updates?
For the collection agency thing, that doesn't apply to in-house collections, correct? Since it's, we don't have to follow that.
I don't think so. Yeah, if you're a management company with in-house collections, I don't think it does, but there's a BUT. I think you need to make sure in-house that you guys are aware of it. I think you guys are. And it's your own internal decision at that point on what you're going to do. Remember, this says before it's sent to the attorney or third-party collection agency. And the management company is not deemed a collection agency, you're the management company, and you're the agent of the association still. And an agent is not a third party, an agent is the association.
Okay.
That's why I'm saying I don't think it applies to any management company with in-house collections.
Okay.
So with you guys, if you send me a foreclosure or whatever after small claims, right?
Yep.
That's when I'm looking for this language.
Okay.
Yeah. You're probably going to see it though anyways because your letter's going to be doing it anyways,
Yep.
right? So they don't have to go back and do it again. Any other questions? Great question. Cool.
Actually, one more. In the language, it says will be turned over. Can it state may be turned over?
Statute, I think the specific language in the statute is will. This is a cut and paste from the actual statute. So that's an interesting point though, because for me, if I say I will sue you if you don't pay, and the board had already told me in the background, we're not sure yet. I'm making a false representation. I'm not saying may sue you, I'm saying will. So that's an FDCPA liability violation for me. $1,000, fine. And there's a million different ways that I could violate the FDCPA. But the statute doesn't say may, it says will. So that's how you have to do it. There's no variation from that language. And so, that's why I'm not going to send it. I'm going to make sure you guys send it. Because you're not subject to the FDCPA.
No. Okay.
Right? Okay. All right.